Your Honor, ladies and gentlemen of the jury, please allow me to introduce myself. My name is Coley Tucker. I represent the defendant in this case, General Hospital. We are here before you today because my plaintiff, Jennifer, feels as though our facility unjustly disclosed her private health information, or PHI. When I'm through presenting the evidence today, I know that you will all see General Hospital acted in accordance with all laws, including Health Insurance Portability and Accountability Act, and took necessary precautions to ensure that all policies and procedures were followed when it came to the plaintiff's health records. Health Insurance Portability and Accountability Act of 1986, as defined by Coddington Lacerte within the Ashford University Library. The Health Insurance Portability and Accountability Act of 1996, or HIPAA, is best known for protecting the privacy and security of patients' medical records. It provides certain patient rights over the access, use, and distribution of personally identifiable health information, as well as criteria for information disclosures and security requirements that healthcare providers, insurance plans, and clearinghouses must follow. Updates to the law since its enactment have expanded patients' rights, regulation of providers, and plans actions and the enforceability of the existing HIPAA regulations. General Hospital has an extensive HIPAA training program that each and every employee must complete yearly to ensure all employees and contractors who have access to patient information are aware of HIPAA regulations and what PHI is. We take any violation of patient rights very seriously, and it is grounds for immediate termination should any staff member violate a patient's rights. HIPAA privacy rules require that any covered entity obtain an individual's prior authorization before using or disclosing protected health information for any purpose other than those listed in the rules. The rules, however, provide for several exceptions to this prior authorization requirement, including where required by law or in the course of a judicial or administrative proceeding. As cited in HIPAA privacy rule, protected patient information requested through discovery, subpoena, and court order can be disclosed. If a HIPAA-covered entity receives a court order or subpoena from a court or an administrative tribunal, the covered entity may disclose the protected health information sought by the court order. A HIPAA-covered provider or plan may disclose information to a party issuing a subpoena only if the notification requirements of the privacy rules are met. Before responding to the subpoena, the provider or plan should receive evidence that there were reasonable efforts to notify the person who is the subject of the information about the request and allow that person a chance to object to any disclosures of their information. As entered into evidence, you will see an envelope sent via certified mail to the address on file with our hospital, as given by the plaintiff at the time that services were rendered to her. This envelope contains information to the plaintiff notifying her of the subpoena for her medical records and request that any objections to the release of this information must be made within 10 business days in writing and mailed via certified mail to the administrative offices of General Hospital. For ease of use by the plaintiff, we also included a self-addressed stamped envelope for the objection to be mailed back to us in, should there be one. You will note this envelope was marked Return to Sender, no longer at this address. This envelope is proof that we as the hospital attempted to satisfy the requirement to notify the plaintiff of the subpoena and requested medical information, as well as the opportunity for the plaintiff to object to the release of this information. General Hospital used the minimum necessary rule to ensure no information was released other than what was specifically listed and requested on the subpoena that we received. This was another measure taken by the hospital in an attempt not to disclose any information beyond what was required by the courts. While I understand the interpretation of notification doesn't specifically define what measures meet this requirement, and the plaintiff never received the notification, and there was no qualified protective order secured, I hope you all understand General Hospital cannot be held accountable for the charges brought against them by the plaintiff, and that we did make an attempt to do the right thing and follow the guidelines as set out by HIPAA.